by an independent and important tribunal. At the same time, under Article 40 ICTR, under Article 6 ACHPR, that means African Charter on Human and People's Rights, as well as Article 7 of European Charter on Human and People's Rights, recognize this right with the phrase everyone, as you can infer from this slide. At the same fashion, when it comes to our country, Ethiopia, under Article 7, this right recognized as everyone has the right to bring a legislative matter to and obtain a decision or judgment by a court of law or any other competent body with a judicial power. So the religious employees are not exception to this rule. On the other hand, when it comes to there is another constitutional principle which is commonly known as secularism. This principle is derived from the freedom of under all instruments, as I said before. Under Article 11, our Constitution recognizes that this right as the state shall not interfere in religious matters and religion shall not interfere in the state affairs. It is this principle that currently our court is used to limit the right to access to justice of religious employees. In the existence of all the other things that I said before, the legislature conditionally exclude employees of religious institutions from the ambit of labor law under Article 3, sub-Article 3b of the Labor Proclamation. When it comes to the judiciary, the Federal Supreme Court Cassation Bench, on its decision on the case between Hammerwork St. Mary Richard versus Diakon Mirat Brahani others and 6 others, held that the formal courts are not competent to see disputes in relation to religious employees, and the Labor Proclamation is not. This case is out of the ambit of Labor Proclamation. This in effect puts many employees of religious institutions the right to access at stake. And here there is a miscarriage of justice on the side of religious employees. Due to this reason, we found it necessary that to investigate and come up with a decisive proposed solution in our research to reconcile the two grand constitutional principles that are right to access to justice and principle of secularism. When it comes to the objective of the study, the general objective of the study was to examine how the right to access to justice of religious employees are interpolated in tandem with the principle of secularism. When it comes to the special objective of the study, the first special objective was to assess the manner in which workers of religious institutions get legal protection to enforce their labor right as a human right in the Ethiopian legal system. And the second special objective was to verify the consistency of the access to justice of religious employees with that of the secularism as prescribed under Article 37 and Article 11 of our Constitution with respect to religious employees. When it comes to the third special objective, was to assess the existence of internal dispute resolution mechanism entertaining the dispute between religious institution and its workers within the ambit of its workers of the organization. When it comes to the fourth special objective, it was to show whether the exclusion of workers of religious institution by Federal Supreme Court Cassation Bench through the interpretation of Article 3, sub-Article 3b of the current Labor Proclamation is compatible with the right to access to justice of religious workers. The final special objective was to review whether the spiritual workers of religious institution could be within the ambit of labor law. When it comes to the research questions, the study attempted to answer the 5 questions as you can see from the slides. To see some questions, the first question was which legislation regulates the relationship of religious institution, with their workers? And the second question was, does efficient dispute resolution mechanisms entitled with the religious institution? And the third question was, does the civil courts are legally competent to adjudicate disputes between the religious institution and its employees? And there are 2 other questions, as you can see from the slide. When it comes to the methodology of the study, the research method, the research is predominantly a case study type. However, to support our reasoning and finding that we get from the case studies, we used data that was collected through an interview conducted with some key informants. This helps us to deal the topic in detail. But to do this, we use snowball and capacitive techniques. When it comes to the data source, throughout conducting our search, we use both primary as well as secondary data source. The primary data obtained from interviews and the secondary data was obtained from books, journals, articles, legislations, and bylaws, as well as different religious documents. When it comes to data collection techniques, since the study was predominantly a case study type, it mainly relied on studying cases, both from our country experience that limit the right to access to justice as we believe, and foreign courses on such cases. Thus, to support our data, as I have said before, we use quantitative data that was collected through key informant interviews. Hammer estimate check, but therefore Abraham was the case that we selected for the purpose of our study, as you can see from the slide. For the purpose of collecting supportive data, as I told you before, we use informant interviews such as judges, victims, potential victims, and the like. Case analysis. The system of case analysis was employed. The selected case was analyzed. When it comes to the key informant interviews, the key informant was interviewed specialists, potential victims, and academics who are closely related with the issue. Data analysis and interpretation, method data analysis. Qualitative method of data analysis was employed. Keep the qualitative information, summarize it and analyze it thematically. When it comes thematically, using the case laws, the ideas that we found from the study. Logical interpretation was improved, and finally, based on the results of our study, we developed our conclusion and recommendation. Thank you. This is my part, and the second part will be proceeded by my research co-author.